Good evening, everyone. Welcome to our weekly Wednesday webinar with the Property Law Alliance. And then I just want to say welcome first to Silna and Bruno. How are you guys doing, Bruno?
Very well, Marley. How are you doing?
I'm good, thank you. And you, Silna?
I'm very good. Thank you so much.
Oh, I'm glad to hear that. Thank you for
I see the
joining me.
question was directed this week, so we don't both speak at the same time.
Yes.
That's probably
Exactly.
worse.
I think Madeline is managing us now. I like it.
It's like you guys speak all over each other. Just you? Okay, yeah, okay.
It's like us, Shay, Madeline. It is like herding cats with Bruno and I.
I'm shy. And then, unfortunately, Greg could not join us tonight, but I do want to take the opportunity and just wish him a belated happy birthday. It was his birthday on the 1st of October. So, Greg, if you're watching, happy birthday. I hope you had an awesome day, and may this year ahead be filled with blessings. And we are fortunate to have you part of the Property Law Alliance team.
Happy
birthday. See, that's what happens if she doesn't manage us.
All right, and then we can get to the questions. We do have a few questions, so that's great. The first one is, he says that we have a High Court judgment issued pre-COVID. Can we execute this in level 1 lockdown? Now, I assume maybe it's an eviction court order that was obtained pre-COVID. I think if we can maybe just quickly discuss the orders which was granted before lockdown and COVID, and if we can execute now. I don't know, Bruno, do you maybe want to take this one?
It's actually a really cool question, mainly because the COVID regulations now are so detailed on the granting of eviction orders and what the courts need to consider when allowing for the execution of the orders. It's I suppose to a certain degree, it's nice that at least the regulations have put some detail into it. Our approach to courts, and also depends on attorneys. So we get some attorneys who their attitude is the courts won't allow the execution unless you prove it. And some of our attitudes is, well, the court should grant it unless those circumstances arise. And there's a difference in onus there, because you tend to find that it depends who actually puts those facts before court and whether the court would consider them or not, and what the standard default position is. My gut tells me, especially coming close to December, that the courts, insofar as granting eviction orders or at least allowing for the execution, they are going to now slow down a little bit, possibly till after December, because we're getting quite close. It tends to happen around December every year. But now to go back to the question, this order was granted prior to COVID. So nothing has been said about whether it can be executed or not, because there was never a consideration in the court's eyes at that moment in time. And this comes back down to what I was saying about owners. So my attitude, and I'm not sure if Selma agrees, but my attitude is that it's if the tenants or if the occupiers want the order to be suspended based on the regulations of COVID, it's incumbent on them to bring a special application to court to say, well, circumstances have now changed. There has to be consideration for that. So they'd want to stay of that order based on the regulations. My attitude is the order is the order. It's allowed. The regulations don't say that it's not allowed. The regulations say the court may suspend. The court didn't suspend. So we're good to go. I know that there are some attorneys, I remember reading a couple of articles from guys in Cape Town that kind of felt differently as to the execution, and they almost felt like it's incumbent on us to now prove that we should be able to execute. My feeling is the opposite. I think we can execute, and if anyone wants to stop us, they must approach court.
I agree with you, Bruno. The problem that we've been seeing in SSLR specifically is that a bunch of the sheriffs, so it depends on the sheriff, your warrant gets issued and everything is good, except you have one of two options where it gets stopped, either on issuing. So we've had, specifically in magistrate courts, we've had issues with the clerk of the court refusing to issue our warrants because it was granted pre-lockdown.
Okay.
And then you're sort of stuck. In those circumstances, your client's forced to bring an application to compel execution of the order. Or on the other hand, you get your order issued, but the sheriff doesn't want to go out. Now that your warrant issued. My problem with that is I can't really see in terms of which court rules or in which part of the world life did somebody decide that a sheriff can decide whether he wants to execute or not. The court orders him to execute. And if the sheriff then doesn't want to execute, I believe the sheriff is in contempt of court, which raises a whole new set of questions. But
it is, yeah.
The issue that we've seen is clerks and registrars that doesn't want to issue our warrants. And that causes a serious problem, because my problem with that is if your client went through all the effort of obtaining an eviction order, now suddenly we can't execute that order. Now you're forced to go back to court for an order to order execution of the order. It's the weirdest thing. But if it's an eviction order, I agree with you. Try and get it issued. And if you get your warrant issued, take it to the sheriff. If the sheriff then executes and the occupant feels that they shouldn't be evicted, cool. Then the obligation is on him. On the occupant, they can approach the court to stop the execution. But when it comes to a writ of execution in the sense of money that is outstanding, I can't see that there's anything, not even in the regulations, that will stop execution on that. So only on eviction in level 1.
Absolutely agreed. Sorry, since we're speaking about the inefficiencies caused by COVID, just a quick question. I should have probably asked you this before. Just regarding, the High Court had some email system failures or delivery failures the other day. I'm just very curious whether you're experiencing the same thing with me. So we had a couple of matters where we sent the emails and there were issues, and now we've had to fight tooth and nail to get them back on the roll because they just simply, the emails did not go through. They were rejected, and then we went to court. Everyone on the court roll had the very same story. Did you experience that?
I haven't seen any of those, and I don't think I haven't heard anything specific from any of the attorneys in SSLR. What I did see, though, yesterday's motion court in South Gauteng was an absolute joy. Poor Nick Brody, our FD, was in court until, Madeline, correct me if I'm wrong, 7:15 last night he obtained his order.
Yeah, our matter
7
was only heard at that time.
Sure.
I mean, remember the days, Bruno, when it was exciting when courts runs through lunchtime.
Yeah.
Now we're running until 7:15, and we weren't the last matter on the roll. There were more matters. There were 27 matters on that roll yesterday, and only 2 matters were heard before lunch, which is why poor Nick stayed on Zoom court until after 7 last night. So
sure,
we haven't seen that problem that you're referring to, but we have we've seen a few other quite exciting problems.
Yeah, no, absolutely. No, because some of my attorneys, even some of the counsel that I work with, having to hijack Zoom links because the matters simply aren't on the roll, and having to jump on, like we had a sequestration where something similar happened, and we had to hijack the link and go in and say it was supposed to be, here's the notes of set down. Unfortunately, it has to be extended. So yeah, I just wanted to find out what your experiences were.
Yeah, no, we were lucky on that one, but let me not jinx it tonight.
All right. Thank you for that. And then we can go to the next question. She says that she has a question regarding rentals. My father-in-law is living in his son and daughter's house that they inherited from their mother. Their parents have been divorced for 20 years. He is living there rent-free, and there is no rental agreement. They have a restraining order against them for death threats. We just found out that another person has moved in there. We were not informed that someone else has moved on the property with him. We do not want other people living there without consent and a rental agreement. What can we legally do? So, Silna, do you maybe want to start with this one?
I must say it's an interesting start simply because to get to the answer, I think you really just need to understand the question first. So for me, my assumption is that if the father-in-law's been staying on the premises, they've been divorced for 20 years. There's so many questions I have that I would like answered actually before I answer the question, but I'll tell you what my assumptions are here. So if I'm working from the premise that the father-in-law took occupation of the premises some time ago, obviously after the ex-wife and mother passed away, took occupation, it doesn't seem like there was an attempt to get him evicted. And there's a restraining order, which is probably or potentially a step towards eviction. Like get the restraining order, see if you can maybe get the guy out. But let's work from the assumption that neither the father-in-law nor any one of the other occupants of the premises are legally allowed to occupy the premises. There's no lease agreement, but remember, guys, what we always say for the benefit of our viewers, the fact that you don't have a written lease agreement doesn't mean you don't have a lease agreement. You can have a verbal agreement, you can have a tacit agreement. Based on the facts that I've heard here, I can't see that there's any form of agreement to occupy. However, he hasn't been removed from the premises. And in terms of the Prevention of Illegal Evictions Act, if somebody is in illegal occupation for a period exceeding 6 months, then the owner could very well run into a bit of a problem where he might be ordered to provide alternative accommodation. Now, very important, the alternative accommodation envisioned in terms of buy isn't alternative accommodation like buying the person a house or renting him a flat. What could end up happening, and this is how our courts apply this provision in the Act, is that the court might allow the person a longer time period to vacate the premises. So instead of giving him a month to vacate before the sheriff can come in and remove him, the court might say, listen, this guy's been in the premises for 15 years. You haven't done anything. Now suddenly you approach the court for an eviction order. What changed? And if you can't satisfy the court with that answer, the court might say, okay, cool, you are still the owner of the property. You're still entitled to occupation, so we'll evict the person, but he has 6 months to vacate. Something like that. That could happen. The people residing with him, unfortunately, derived their sort of right, quasi-right, to reside through and under this person. So what an eviction will look like in a situation like this, you will have that person, the father-in-law, as the first respondent, and then you will have all the other occupants, and they will be called all other occupants of the property, known as whatever the address is, and that will be your second respondent. In a case like this, crucial to have the municipality as a respondent, because I can clearly hear in this situation, there will be a defense from the respondent saying that they will be left homeless and destitute, and they need alternative accommodation. So be preemptive and already bring the municipality into the equation, because like we know in terms of Blue Moonlight Properties and a bunch of other cases, if there is a requirement for alternative accommodation, that is a municipal obligation. But to get to that point, the owner will have to appreciate that they have to actively act on this. What I've seen from evictions, I've been doing evictions for a little bit more than 12 years now. So I think I've seen an eviction or two in my life. And what I've seen is the most important thing is to act as soon as there's a problem. To wait and hope that the person is going to leave or whatever, it never happens. So get going, take action immediately. Even if you don't have the money to pay for a full eviction yet, just get to the right lawyers. Seriously, this is a specialist field of law. You need to get to expert attorneys on this so they can start going on correspondence and things like that. Bruno, that was a long story, but now the floor is yours again.
Well, look, you spot on. You spot on with everything that you said. Reality is the longer you take to take action, the harder it is to get the person out. Simple as that. Because as soon as, and I keep telling this to people, eviction or land ownership is a psychological thing. Home is home. People that live in a certain place will make it their home, even if it doesn't belong to them. Sooner or later, they will start becoming attached to it. And you cannot be surprised when this happens. So act now when you can probably mitigate the issues, as opposed to later when it becomes too late and the people have an attachment. And the worst thing that you tend to find, I know it's not the circumstances here, but people then start doing renovations and saying they have liens over the property. And it's a disaster. And it lands up being just a nightmare for you the longer you do it. So act now. But
Exactly.
just to go back to the one interesting thing about this question that I always have issue with when it comes to these type of evictions is the family relation. Because let's say, for example, the scenario existed and the person had been living on the property for years, but they weren't necessarily related. They were just some random person that's there. The same considerations would apply. The things with father-in-laws and ex-husbands or present husbands, I'm not sure if they were divorced or not. And things, for example, you start bringing wills into the picture. Guys, be careful, because now with the family relations, there's an extra layer to this that always comes about in court. I can promise you, I'm doing an eviction now in Durban where our client, the innocent property investor, he bought the property, but now there's a dispute as to whether the person that sold it to him should have even had it to begin with, because she was the mistress and she's the real wife and these are the children and there's a will and no one has any money though. So it just gets very complex. So family matters, just take it one level further and just make sure that you understand the dynamic on where the property should have been, what the will said about it, whether there was some kind of right of occupation to begin with, and if there was any intention to carry on that right of occupation or not. And if the property was basically bequeathed through to you entirely without, not subject to anything, then at least you know that you're good and there shouldn't be any disputes. But just be careful with that. It's always like a red flag that comes up.
Okay, perfect. Thank you so much for that. Then we can go to another question regarding the TPN rental deferment agreement. So she says that we tried to assist our tenants during lockdown with a payment plan. They signed and agreed to the deferment agreement offered by TPN. The first month of payment plan, they didn't pay back, so we took immediate action with lawyers. We followed procedures of eviction for our tenants that haven't paid now for 3 months. We got a court date and the tenant pitched up at court, pleaded to get a second chance. He keeps saying they've got nowhere to go. We didn't accept their proposal as they've been giving endless promises of payment, however, haven't paid their rent. The judge said to the tenants that they must pay rent while they stay, but still they are in arrears 3 months. The next court date is the 17th of October for hearing. By when is the latest that these tenants can be evicted? And then the last question, the lawyers said they'll still be liable for payments. Can we hold them to this? All right, so I don't know, Silna, do you want to get started on this one as well?
I get all the fun ones. Bruno, luckily there's a lot on this, so I can take a few bites and then I can pass the leftovers to you there, because there's so much on this case, on this particular question. So I think a good starting point, and now I'm not even going to get into the actual eviction side of things. I'll leave that for you. But I think something very important there is she makes mention of the judge that said, shame, we'll give you more time, but you need to pay your rent in the meantime. I must say that's a very interesting order. I would like to see
If it is an
details.
order, yeah.
Exactly. I would like to see details on that, because also the term judge makes me feel they were in the High Court, obviously, but that just doesn't sound like a judgment. So that I find it quite interesting. I say this knowing that very often the terms we use as attorneys in the way that we talk to each other, for instance, Bruno, our clients, half the words we say, we really understand what we're on about, but it could fly a little over our clients, and I think this could potentially be one of the things that happen. The fact that there is a specific court date, the 17th of October, makes me think that there was a postponement, and at the time of the postponement, the judge or the magistrate, which I think is more likely, the magistrate probably said to the occupant, remember, while we're sorting this out, just remember to pay your rent. It would be a comment in passing from the bench, and it's not an order per se. It won't be a court order per se unless it is, but it doesn't sound like it. It doesn't sound completely right. But then also, back in court on the 17th, you might very well get your eviction order. Then the question around your attorney says that the tenant is still liable for rent. Can you hold him to this? So I don't know exactly who should be held to that, the attorney or the tenant. What I can say is the attorney can definitely not be held to that. The attorney can say in law the tenant is obliged to pay for his occupation. 100% correct, whoever the attorney is, well done. That is the correct answer. Unfortunately, our legal advice that we give and the position in law, that we can't be held to it in the sense of, if they don't pay, then you can claim that money from your attorney. That's definitely not the position. But I think when it comes to the actual eviction there, Bruno, I think we've dealt with this quite a bit. Is there anything that you want to add on that?
I know that part of the question, if I'm not mistaken, is there's a court date on the 17th. When is the latest that the eviction can take place? So I kind of addressed that in the first question when I said the problem is with Christmas coming up, you're either going to get very lucky and an order. So 17th of October, you might get lucky in 30 days. 3 weeks to 30 days, you might get 17th of November. So you may be one of the lucky few that still has their matters on the roll relatively soon. As soon as it starts getting to end of October, beginning November, it starts becoming basically a trial and error, and you see a lot of judges pushing for your end of January's type of thing. But that's obviously no one wants to see people on the street during the December period, during the Christmas period. Yeah, so when would the eviction possibly take place? No one knows. It could still be this year, or it could potentially be next year, depending on the circumstances and depending whether the occupiers, what their financial position is. Will they be rendered homeless? Is this a consideration that the court has to take into account? Have they pleaded this at any point? Because the courts will be forced to take that into account and make a ruling according to that.
Yeah. And I think important, Bruno, you touch on something very important. We know what evictions look like November, December, Jan. Yeah. We know that the courts extend execution of the orders. We know that the sheriffs are reluctant to execute. We know these things. But this year is such a weird outlier year. Honestly, I can't even predict what the answers is. I must say, I've seen the courts already, even during July, August, September, giving longer time period to vacate. We've had a few relatively normal, straightforward residential evictions where the court ended up giving the people 3 months to vacate, 90 days. Where in other cases, we still get evictions basically immediately. They need to vacate now and you can send the sheriff in a week. We still get that. But at this stage, I'm so reluctant to guess what's going to happen over this Christmas, New Year and New Year situation, because it depends completely on the judge that you draw. And you could draw a judge that feels like, oh, shame, it's already been a tough year. Let's not put people out. you end up, like you said, Jan, Feb next year. So I have no idea. I think it will start to crystallize a little in the next few weeks.
Absolutely. No, I agree.
Okay, perfect. Thank you so much for that. And then we do have one comment from Seshoka. He says, thank you for SSLR for TPN agreement to vacate form. My tenant vacated after signing it. Although they left owing me a rental, at least I got my property back. So that's
Nice.
good to hear.
Well done.
Then you can at least
I'm
place
so
a new
happy to
paying
hear
tenant
that.
in the property.
I'm so happy. Thank you for that comment. I really appreciate that. It's nice if you work on something and it adds value. So thank you for that comment.
Okay, perfect. All right, then it was the virtual property show this weekend or on Friday and Saturday. So I want to ask you, did you have any interesting scenarios or questions that you had to deal with? I hope your talks and everything went well. I'm going to ask you first, Bruno. What was your experience and did you have any interesting questions?
No, absolutely. It was an absolute great experience. It was so different. The team building aspect of it was great because we all sat in the office together behind our laptops, like chatting to each other in the background. So that was pretty cool. The property show in itself, it was great to still listen to those talks. Obviously, there was no human interaction, so to a certain degree that was missed. But I suppose, like everyone said, it was great not to have to go home with your feet sore because you've been standing the whole day. And now you're just exhausted. So like last year's property show, I was just buggered. We ended up going out, granted, but I shouldn't have. I was tired. I should have just gone home.
We weren't friends then yet, Bruno.
No,
After work.
last year it was just, well, we were chatting.
Yeah.
I still remember we collaborated on what we were going to say, but no, we weren't drinking wine together yet.
So that's good. It's a blessing in disguise because if it was now, we definitely would have enjoyed the after show drinks even more.
Absolutely. Yeah. I did get a pretty cool question. I just thought maybe it would be worth discussing because a lot of people tend to ask that, and it varies from the eviction questions we normally get. So it was, would you agree that to allow more real estate agents to sell a single property gives a owner more offers? What are the disadvantages of this? And I did address it there, and I just thought, you know what, a lot of people tend to ask that, and we have quite a few estate agents that watch this webinar as well. I think it's just important. It's a long conversation to have, so we could actually save it for next week and really discuss it. But I think people just need to realize, guys, be careful. Double commission is a reality. There's case law where the judges have ordered sellers to pay double commission, where for some reason or another, both agents were somehow involved in the sale and were both considered to be the reason, the primary cause for the sale of the property. And it is possible for this to happen because you can think of circumstances where both of them kind of build on each other. And arguably, one could have not done it without the other. And it is a reality. So guys, be careful. When signing open mandates and having multiple agents, you need to take some extra steps to make sure that you protect yourself. There's a couple of different tricks. Everyone has their own tricks. I normally suggest first trick is cater your mandate properly. So your mandate, so when commission is due, is actually catered for by you, not by what our law says, because our law says who's the effective cause of the sale, and that's very open to interpretation. So you could actually change the mandate to say you will earn commission once suspensive condition is fulfilled, and that's it. And that is the person that owns commission. So even if you showed the property to the guy 1 million times, if the offer doesn't come through you, sorry. And I know estate agents don't like this because they feel it's unfair, and I agree. But the problem is, from a seller's perspective, you need certainty. You need to get some other. A second option is to have it in the contract. There's some form of indemnity. by the purchaser. So the purchaser signs the offer and indemnifies the seller and says, if for some reason you get another claim for commission, because I failed to disclose to you that I actually phoned another estate agent at some point showing interest in this property, I'll indemnify you and I will pay that commission on your behalf. But granted, for what it's worth, the purchaser would actually have to be able to pay that commission. So there you might still have an issue with collections. So be very careful. I had a trial recently where, where something similar happened and the purchaser didn't disclose anything to us, to my client, the seller. And eventually when we confronted him and said, but what happened? He said, yeah, well, the agent came there and he was driving like an old Skoro and I didn't like him. So I just decided to go there. I went 2 weeks later and I called the other board and they showed me the property. And we were actually at a point where the problem was, is it enough that you didn't like the agent's face? Because the prices weren't different. There wasn't any substantial deviation. The second agent did not do enough to be considered to have closed the deal. So as far as the court would have been concerned, we feel, we managed to settle it fortunately, but my gut tells me the court would have looked at it and said, guys, listen, you can't just say you didn't like his face, so you called the other guy. He showed you the property. He ran you through everything. That's enough to show that he was some predominant part of the effective cause.
Mm-hmm. I agree with you, Bruno, and I think the only thing I would want to add to this conversation, but I think it's a good one to go into a bit more depth when we have time, but I think something very important for me is for both sellers, purchasers, landlords, tenants, agents. The one document that people are always reluctant to sign or reluctant to get into writing is a mandate agreement. And whenever I do rental training for rental agents, and I say, guys, get your mandate signed, ideally when you list, an authority to list when you list, but you want a full mandate agreement signed by the time you sign a lease agreement. The sales slightly different. You want to get a signed mandate when you list, because you don't want to be the unlucky agent that lists and you lucky one that gets picked up in a day or two without a signed mandate agreement. How are we going to prove the amount of commission? It's like you said, as much as you can prove the effective cause, which agent was the effective cause, brilliant. But what is the commission that goes with that? What is your commission percentage? And I almost want to, seriously, I want to encourage not just estate agents to focus on getting signed mandate agreements, but this has to come from the landlord and the seller side as well. Remember, guys, you as the landlord or you as the seller are the person paying for a service from the estate agent. If you don't have a signed mandate, how can you keep the agent to what they've agreed to do for you? So signed mandates, I know documents are an absolute pain for everybody, except for an attorney. I will sit with my little red pen and a contract, and I freaking love reading it and go back to definitions, and I get a kick out of that. I know it's not for everybody, but get that, because that is the easiest way of keeping you out of court. If you have a proper document, regardless of which party you are, and your rights and obligations are clearly set out, life suddenly becomes so easy. It's like the comment now on the agreement to vacate. Yes, fair enough. We've had this conversation a million times, Bruno, to actually enforce that agreement to vacate. You're still going to have to follow by process, but at least the parties are clear. Marily had a matter today where there was this issue of a settlement agreement on a judgment. And I kept on saying, just get the document signed, because then all the parties know where they are, where they stand, and what we can enforce. It's such a crucial element. So just make sure that your mandate agreement is signed, but that all the parties understand what they're signing. Don't just sign a document because it's long. Understand what it says and make sure it's simple so everybody understands it.
Absolutely, yeah.
Perfect. Thank you for that. Ms. Silna, I just quickly want to ask you as well what your experience was with the virtual property show, and did you have any interesting scenarios or questions or anything like that?
You know what? I must say it's far out of my normal way of doing things. I love the property show, and I love trainings in person, and I love chatting to people over tea before and after a seminar, and the same at a show. I love, you know, having coffee with someone, sit down, really just get to see the industry people again, catching up where everybody is and what they are doing. And it was sad for me on the virtual show that there was none of that, for obvious reasons. At least everybody is safe and healthy. I think that's more important. But I missed the real interaction, the real human interaction. But I think for first off, it really achieved the goal. It was interesting. We got some of the stats back. Majority of visitors was actually between 25 and 45, which makes a lot of sense. I think it is that group of the industry that would be at a virtual show. And I do believe the visitors that attended got some proper value, especially considering that it was a free event. I think it was a very valuable thing. No, I think private property, really kudos to them for trying something that hasn't been done before. So well done, private property. I think you guys can definitely be proud of yourself. If there weren't a few glitches, I would have been worried that the system was rigged. But I think all things considered, it actually worked out pretty well. So yay. But nothing specific that I want to add on that one.
Okay, perfect. Thank you so much for that. And then I think that is about the time that we have. So, all right. Thank you so much, Bruno and Silna, again for joining us. And then for all our viewers, have a lovely week. And then we'll see you next week, Wednesday.
Awesome. Thanks, guys. Thanks, Marty.
Okay.
Thanks, guys.
Bye.
Bye-bye.